Welcome back to another episode of Candid Conversations. I'm Renee Marzoff here with Tuni Kabir and Taylor Haas, and special guests this week, Samantha Santee and Ryan Bauer, to provide us with a legislative update.
Yes. So, with all of the new legislative bills that have been passed, tell us the updates. What has come about it?
Yep. So I'll go first. I was really focused on two bills. One is not so big. It was the bill discussing reasonable modifications. The really big one that I'm sure everybody wants an update on is 1098, the cause required for residential evictions. And I'm more than happy to go into a ton of detail on that, so cut me off whenever. But basically, it just limits the reasons you can evict a tenant and the reasons that you can non-renew a lease anymore. Basically, get them out at the natural end of a lease. Those highlights are that if you're selling, demolishing, or converting, if you or a family member, and that's as defined by law, so like your uncle's great aunt doesn't count anymore. There were a couple other ones, history of non-payment of rent, if the tenant refuses to sign a new lease, that kind of thing. Then we can give your tenant a minimum of 90, that's right, 3-month notice, 90 days notice, and then ask them to vacate at the end of the lease. That 90 days can't end sooner than the lease naturally ends, but it can extend beyond that at the same terms of the current lease. If a tenant refuses to sign a new lease, and let's say that we sent them a lease renewal offer 60 days before the end of their lease, they didn't let us, or they didn't sign it, and let's say that we decided to offer them that 90-day notice to terminate at the end, or 30 days before the lease ends, that means that they get to stay in the property for the same terms at the same rent rate for those extra 60 days after the end of the lease. So that's definitely something that is going to change our internal policy and in our internal process. If you're an existing owner, you're going to get that renewal offer about a month early, just to make sure that we have enough time to give the tenants a good amount of time to accept or decline that, and then still give them their 90 days notice at the end. If they hold over at the end of the 90 days, we can go through with what's called a no fault eviction. That is still a legal eviction through the court system, but it basically, the judge would say, well, it's not really your fault, Mr. Tenant, that you didn't vacate at the end of the lease when they said, hey, here's your 90 days. So it looks a little different on the legal side, but it's the same process overall. We also have some updated internal requirements for posting our notices. Those timelines have changed. Instead of being able to knock on a tenant's door and if they don't answer, post in a conspicuous place and walk away all at one time, we get to knock on the tenant's door. If they don't answer, we have to leave and come back on a different calendar day and then knock again and attempt personal service. And when they don't, then we can post in a conspicuous place and walk away, so that it extends our timeline on the front end a little more. And also now we have to ask everybody's primary language, because those notices must also be posted, and these are rent demands essentially, and demands like eviction demands. They must be posted in a tenant's primary language. So that means if your tenant speaks Arabic or Japanese or any language under the sun, we have to get that form translated in their primary language and posted accordingly.
All right. And next one we want to jump into that our group's been focusing on quite a bit was SB 24-094. That's going to be the safe housing for residential tenants. So this was actually passed in early April, finally effective on the 3rd, May 3rd. So this one just is actually a rewrite of the previous warranty of habitability bill that went into effect quite many years ago. But this one is really just going a little bit more general with this whole process. So it's adding things like air conditioners, permanent cooling devices, and portable cooling devices as well to the list of appliances. So this can be a little bit sticky and tricky, especially in a state like this where it doesn't get incredibly warm in the scheme of just the climate of the United States. So that's not something that we've had to operate on in the past. And now that's going to be added to the list. And another thing, the main piece of this that's getting a little bit more difficult is the timeline and the language that is described as uninhabitable. So the uninhabitability definition would be interfering with tenants' life, health, or safety. And that gets a little bit more broad and gray now, because it can be defined in many different ways what's interfering with someone's life. And that's what we're planning on having a lot more conversations about to try and attack. So things like if your blinds are broken, could you potentially say that interferes with my life? So we're going to see what kind of claims we do get about that. But we do have some plans going forward to address these kinds of things. But yeah, the timelines and the definitions of that uninhabitability timeline is what we're really going to be jumping into here in the next several months.
Awesome. So with the laws that you mentioned, how is that affecting what we do today for the properties we manage and the clients that we work for?
Yeah, I can start on this one. Yeah, so definitely from a maintenance standpoint, obviously I being in maintenance, there's a lot of things that we have to do day to day, and a lot of things that we have to attend to right away as soon as they come in. So obviously now with the timelines for these habitability situations and these maintenance emergencies that we do get day to day, it's just going to require a lot more attention to detail and the times that we are taking to handle these kinds of things. Not to say that prior to this we did not take those measures, but ultimately there's going to have to be significantly more rapid communications with the vendors, with tenants, with owners, constant check-ins with all those parties, with vendors, owners, tenants. We actually do have a new feature with our maintenance software, which is going to be great going down the line, that has a full AI summary of exactly the communication with the tenant and the vendor that can break it down for us, and we can send that to anyone that's necessary. So say an attorney letter comes in, if a tenant does submit something, God forbid there, but we can actually send that to them, that full breakdown. They can see the exact communication. So it's going to be constant communication and just significantly more of it.
Sure. And so Ryan, just reiterate for us, what is the timeline that's required of the landlords now?
Yeah, so it's ultimately it's the time that they have to commence that remedial action. So it's 24 hours where the condition materially interferes with the tenant's life, health, or safety, and 72 hours where the residential premises are uninhabitable. So that is the amount of time that we would then have to act on something and potentially remove a tenant if that's defined that way.
Okay, so it's basically just the initial of either making a plan of action. It's not the time that it has to be actually completed being corrected, correct?
Correct. The amount of time now that it has to be fully corrected is 14 days.
Okay, so in your experience with all the maintenance emergencies you've dealt with, is that achievable for, you know, our company or self-managing landlords? Like, how does that timeline make you feel?
It's a great question. It's a great question. They can go A to Z, wall to wall. These situations are truly, there's no limit on it. So long-winded answer would be it concerns me a little bit, because I've seen situations take anywhere from 1 hour to resolve to 75 days. So I know that can sound a little scary. Just hearing that you have 14 days and it's taken that long to do certain things, but ultimately that's the position that we've been put in here, and that's what we're going to have to try and work on. So ultimately, yes, it is a little bit concerning, and some of these timelines are not necessarily feasible. But as long as we are keeping that constant communication and showing action each day, with every sort of phone call or email or message that we do send, pushing the ball down the line, actively working to get the job done and find a solution for the tenants, then we feel confident that we're going to be just fine.
Absolutely. Yes, I'd say for clients that we work with and prospects that we're talking to that are interested in hiring our services, we always recommend that you have at least 2 to 3 months of your mortgage or the rent payment in savings. It doesn't matter how new your property is or what type of warranty you have, stuff happens. And being that now there's a stricter requirement on timelines, we of course want to make sure that you're covered so you can accommodate the new legislation and of course make your tenants happy. But how about you, Sam? What about yours?
Yeah, so I talked about it a little already with the expanded renewal sort of timeline that we are working on. We used to do everything 90 days out. Now we're looking at a minimum of 120 days out. So that's definitely going to be a change. We also are being a lot more, a lot less lenient, we'll say, with some of our tenants who pay later. Rent is always due on the 1st. It's late as of the 2nd. Colorado law mandates a 7-day grace period. So normally we would give our tenants, about the 9th to pay before we really moved forward with any sort of rent demand. Just because, there was an argument that, about the 9th is when you should expect to pay it. But now, since again, we need some actual documentation in order to establish a history of non-payment of rent in order to non-renew your tenant at the end of the lease, essentially. And that means that we have to have a minimum of 3 late payments as defined by law, which is now that they must be properly served. So they have to have an official notice, and they have to pay after the notice period for us to say this is an official late payment. And that's one of our 3 strikes. How would it affect the industry at large? No, you can't just non-renew a tenant for any reason now. The relationship didn't work out, maybe it didn't quite work, there was some friction there, but nothing that really established a breach of lease or a nuisance, as defined by law. There was no criminal conduct, anything like that. We don't have that option anymore. So it doesn't matter if your tenant isn't keeping care of the yard like you really want. If it doesn't extend to a full breach of their lease, a material violation, a repeat, or a substantial violation, we have to keep it going. If there's no reason to non-renew them for cause, basically, or for no fault, which is that list that I gave earlier, the lease extends in perpetuity. That doesn't mean that your tenants don't have to, now don't have to give you notice, or that they are also required to give you a 90-day notice. They can give notice, the day before the end of their lease and say, hey, I'm out, peace, and just drop the keys on the desk and walk away. But that has been the case for a couple of years with the prohibited provisions bill that passed a couple of years ago, basically saying that we couldn't penalize the tenants for not providing us notice. So that's not really anything different. It's just that it's a little less fair now than it was last year.
Sure. I know we talked about in a recent team meeting that the silver lining to the 90-day requirement is now we know with even more notice than we did before what our upcoming move outs are, so that we know what the volume is on our team. So that at least is nice there. I personally have received phone calls from property managers in our market asking how we are accommodating this new requirement to serve twice. Luckily for us, we have been using a legal process server since 2020. So we just updated our instructions and we're able to serve it that way. But I think with any law, the unintended consequences are the amount of man hours that's needed now to accommodate this, and just kind of the additional stress that it puts on tenants. Because now someone's coming to their door and trying to hand something to them in person. And before, we already got complaints that people felt embarrassed in front of their neighbors when people were delivering and posting stuff to the door. So we'll see how that continues to shape up.
Absolutely. And thankfully for our clients, there's not as much for them to have to worry about because, like you girls have mentioned, we're changing our processes and we've got things in place. Ryan's taking care of those maintenance changes too. But for landlords that are self-managing, maybe they don't have their own processes documented and they're having to keep up with all of these changes and what that means for them. How are these bills going to be affecting landlords who are trying to self-manage their properties?
Yeah, definitely. It's a great question as well. And I think a lot of that will just come down to, just education. Just do the best you can to educate yourself and really stay on top of these kinds of things. We have plenty of resources that are accessible for these kinds of things. If there are any questions, we have plenty of FAQs on the site as well. So just doing your best to educate yourselves on anything that you see that comes across, anything that we've spoke about. There's a website as well. You can just go on to the Colorado just government website. Essentially, I believe it's ledge.colorado.gov. Sam could confirm that one way or the other, but that has all the information about any of these bills. You can see all the bill text, the entire process, copies of the bills as well. They can be a little bit old English in terms of the words. So if you have any sort of clarifying questions, just feel free to reach out to us as well. But yes, I would say number one would just be education, educate yourselves.
Yep. Yep. You had that website right on. I just checked. It's leg.colorado, all spelled out, .gov. Like Ryan said, the bills are always in legalese. Sometimes they can be very difficult to understand. Education is definitely the number one. You know, we really try and keep our team as educated as possible. We attend webinars, you know, we attend CLLC events and NARPM events that are specifically geared for property management education. So like that is our number one focus also, is just staying on top of everything, understanding how this changes our process, understanding what it means for the industry, and kind of like we rely really heavily on our attorneys, you know, everything like that to keep us on track and in compliance. I would say if you are a self-managing landlord, if the stress is too much, if you are looking at some of the penalties, some of the new bills that have come down, you can't keep up with it, you're not sure if you are in compliance anymore, if you're just over the headache and the hassle of dealing with this, hire a property manager. Like, we are the professionals. We do this literally for a living. You know, this is how we get paid. That this is what we do. And we exist to make sure that you and your tenants and your lease and your property stay in compliance. So if it feels like, if you're more afraid of keeping a rental property in Colorado than you were yesterday, call us. Call us, you know, give us a chance. Don't run for the hills yet. You know, don't leave Colorado yet. There are still people here who are working, who are, you know, really trying to make sure that we still do have your best interest in mind. But if it's getting too much, you know, call us. Call us. We'd love to take on, you know, we'd love to help you. We'd love to, you know, give you that education or those resources that we can. But mostly, you know, we'd love to just take it all away from you. Just let it be our burden instead of yours. But yeah, if you wanted to be a little more involved also, or, you know, just keep up on some of that education in the news and the legislation, the CLLC, the Colorado Landlord Legislative Coalition, is a wonderful resource for individual owners, individual landlords, things like that, property owners who are self-managing, or just, you know, property owners or property managers. We exist to, you know, basically act on your best interest in the legislative process. So we'll take your money and spend it in a really good way.
Awesome. Yes, lots of changes here across the state, but Colorado is still an awesome place to have an investment property, whether you're purchasing an additional investment property or maybe you're moving away for a little while and hope to be able to come back, because who wouldn't want to come back to Colorado? It's still a great place to have a rental property, and we're here to make that as easy as possible for you. So that's all for this week, but we'll chat again soon.